All right, good morning, everyone. This is our special council meeting of Wednesday, October 15th. It is 10:32 p.m. and I will call the meeting to order. I acknowledge that all members of council are present except for Councillor Borzos and Deputy Mayor Laux, who does send his regrets. Before I begin to the land acknowledgement, I just wanted to acknowledge that today's meeting is going to be held in two locations. So the first part of the meeting is being held here in council chambers for the purpose of a training for the under the Drainage Act. And then we will recess the meeting and pick the meeting back up at the Colgan Wastewater Plant, which is at 59 Sparrow Way. And at that point, council will be proceeding to go into closed session for a training opportunity to tour the wastewater plant and operations at that location. And then following that, we will reopen the meeting at that location and then adjourn the meeting and pass the confirmation bylaw. So that was all the aspects of the meeting today. So with that said, I will state the township land acknowledgement. The township of Adjala-Tosorontio is situated on the lands within Treaty 18, being the traditional territory of the Anishinaabe peoples, including the Ojibwe, the Odawa, and the Potawatomi nations, collectively known as the Three Fires Confederacy. This land is home to many diverse First Nations, Inuit, and Métis peoples. We acknowledge the Indigenous peoples as stewards of the land, and we honor their resilience as well as their culture and have our shared respect for the lands, plants, animals, and waterways which sustains us all. We recognize the injustices against Indigenous peoples and are mindful that the decisions of government impact our shared land and all the inhabitants. We commit to reconciliation as a journey to foster Indigenous cultural awareness and educational opportunities, establish respectful and healthy relations with Indigenous peoples, continue to steward the land and its inhabitants, and to cultivate an inclusive community for all. So we're on to item 2, which is the adoption of the agenda. The recommendation is that the agenda for the special council meeting held on Wednesday, October 15th, 2025 be adopted as presented. The mover, please. Councillor Simpson, seconded by Councillor Cox. Any questions on the agenda? And as I explained, we will be having portion here and then back down to Colgan for the second part. All those in favor? And that is carried. All right, item 3 is disclosure of pecuniary interests. Are there any at this present time? And seeing none, if you do find yourself in that spot at a later time, please declare. And then we're on to 4.1, which is presentation from Sid Vanderveen, Municipal Drains Lead from R.J. Burnside and Associates Limited. And it's a review of the Drainage Act and Court of Revision training. So Sid, welcome. Thank you very much for coming in. A bit later today than last time, so I'm sure you got a chance to sleep in a wee bit. But welcome, and we appreciate the update on this training, and particularly the Court of Revision, because I think that's something that's going to be coming forward to this council in the near future, and I think that training is imperative for us to understand that process. So thank you, and begin when you like.
Thank you, Mayor Anderson. And just to confirm our earlier discussion, we are open to questions throughout if you so choose. Okay.
Yes, that's fine. So council, if you'd like, Mr. Vanderveen has said that he's okay with questions throughout, just as long as we're not focused on one slide particularly, rather than wait till the end. So I'm sure you can answer as we go if there's questions.
Thank you. Okay, today's session, the primary purpose of it is Court of Revision training, and some of you were involved in or participated in the training session that I gave about 4 or 5 years ago on the Drainage Act. And so some of this will be review, but I didn't think I should get into the Court of Revision without first doing a bit of a review on the Drainage Act itself. So again, for those of you who heard my presentation from 4 or 5 years ago, apologies, but I think at least a review is necessary. So, sorry, is the slides coming along? Okay, so here's what I'm planning to cover today. What's the purpose of the Drainage Act, which is really a little bit about common law. And common law, to be very clear, is totally separate from the Drainage Act. It's just that it has some elements that relate to the Drainage Act. So then I'm going to get into the petition drain process, a review of that. Then I'm going to, a few slides, only a few on municipal drain management, and then I'm going to get into the quarter revision training. Next slide, please. So what is the purpose of the Drainage Act? And next slide again, we inherited our laws from Great Britain. Our foundation is from Great Britain. And with that came two forms of law, statute law and common law. The common law is what I want to talk about first. The principles of the common law are all based on court cases. So you don't open up a book and say, here's what the common law says about drainage. You actually have to research court decisions. So how does that work? Next slide, please. Oh, yeah, next slide again and again. So the way, this is my vision of the interaction between common law and statute law, but common law is kind of our foundation. It applies to anything. I've used the line that anybody can sue anybody over anything under common law, and that's the principle that's trying to be shown with that foundation. And then we come along when common law doesn't work very well, the province and the federal government pass laws that override or clarify some aspects of the common law. And so what you're going to hear is some aspects of common law as it relates to drainage, and you'll realize that as a municipality, as property owners, this doesn't work very well in a jurisdiction of the world that has an abundance of precipitation. Great problem to have, but we need some sort of a mechanism in order to deal with drainage issues. Next slide, please. So first of all, what does the common law say? Again, it's all based on court cases and the precedents that it sets. The first thing that I want to talk about is natural water courses. The courts basically divide, when it comes to drainage, the courts divide into two parts: water in a natural water course and surface water. Different sets of rules. What's the dividing line? When does a surface water become a natural water course? Well, it has to fall within this definition. A natural water course is a natural stream of water with defined bed and banks that flows for sufficient time to give substantial existence. I don't know what those terms mean. I don't know what sufficient time or substantial existence means. It doesn't really define it in any of these court cases, but what it does say is that if you have an opinion that it's a natural water course and your neighbor doesn't, it may be grounds for a lawsuit. Now, if it is clearly a natural water course, then the owners adjacent to a natural water course are called riparian landowners. They have rights that non-riparian landowners don't have. And the first right that I'd like to talk about is the right of drainage. You will hear people talk all the time about my water. I have the right to drain and my water has the right to flow downhill. If you're not a riparian landowner, you don't have that right. You may be able to acquire it, but you don't have that right. Only riparian landowners adjacent to a natural water course have the right of drainage. Now, keep in mind that the township is a property owner, and its roads are under the same level as any other property owner in the province. So when you well, we'll talk about that in just a little bit, but so only riparian landowners have the right of drainage. Only riparian landowners have the automatic right to use water from a natural water course for domestic purposes, like their well water, or their water for house supply, or feeding, watering cattle, or irrigating crops. Only riparian landowners have that right. And you'll see that doesn't work either, because there's other property owners that do require drainage. Require water for their own purposes. So how does that interact? Well, there's a statute law for that. There's also some responsibilities for riparian owners. They could be held liable for damage if they channelize a natural water course. And yes, you have to get all the permits and approvals. That's where statute law kicks in. But under common law, you could have all the permits and approvals and still be held liable from your neighbor for damages because you've done something that impacted them. Likewise, if you remove a natural blockage such as a dam, such as a beaver dam, you could be held liable for those damages. Or if you change your land use and it results in more water going downstream, you can be held liable for damages. There's a theme here. Common law, it's all based on court cases and the liabilities that come from that. If you relocate a section of natural water course, again, got all the permits or whatever, you could still be held liable for the damages that result from that. So that's natural water courses. There's some rights, but there's some severe limitations when it comes to liabilities as well. Next slide, please. So surface water is basically any water that's not within the definition of a natural water course. And the courts have made it very, very clear here. Number one, you have no right of drainage. So again, back to the property owners saying, I have a right of drainage. I have the right to flow my water to flow downhill. Actually, no. If it's surface water, what the courts have said, no right of drainage. Not only that, lower property owners can put up berms or dikes and stop the flow of surface water from coming onto their property under the common law. Further, if you collect surface water, such as talk about farm tile drainage systems or even roadside ditches and culverts are forms of collecting surface water. If you collect surface water and you discharge it onto somebody else, you can be held liable for the damages that result. So there's a few examples on that slide of things that we do as humans and in the form of dealing with the collections of surface water, agricultural tile drainage, road ditches and culverts, storm sewers, stormwater management ponds, surface swales, all forms of collecting. I dealt with a property owner who complained to me about his neighbor who took his eaves troughs and downspouts and directed it over onto his neighbor's property. And the neighbor complained because it was right onto their vegetable garden. Form of collecting surface water. Another example was emptying the swimming pool. And again, people are difficult to deal with sometimes. They emptied the swimming pool and they directed it onto the neighbor's property. All these are potential liabilities if it went to court. Next slide, please. Now there is a limited right of long-standing collection of water and directing it onto somebody else. And it's called a prescriptive right. Now there's, again, I want to limit this because there have been some recent changes, but if surface water has been collected and discharged onto somebody else for over 20 years, you may be able to claim a prescriptive right of drainage. You need to look at the Real Property Limitations Act to see the basis for the 20-year time period. That's only based on the current land conditions. So if you had a road culvert that was directing water onto an adjacent property and nothing changed and 20 years passed and then year 21 they decided to sue the municipality, you could use the claim that we have a prescriptive right of drainage. But if in that time period you developed the road, you paved it, you did ditching, and you increased the water onto the neighboring property, then you probably have lost your prescriptive right of drainage. And again, the bottom line of that slide, prescriptive right of drainage can only be granted by the courts. You don't have anything until the courts actually say you have a prescriptive right of drainage. I have one court case that I want to review. I've used this one a lot. Next slide, please. And it's called Durbecker versus Lynch. It happened in Gray County, and the upper property owner, higher in elevation, it's an agricultural example, a fellow by the name of Durbecker, he had a pipe that existed for years and years, and it outletted about 300 feet from the property line of Lynch. But he went and had some agricultural tile drainage installed, and that system collected surface water and it discharged 20 feet from the fence line. And it started to cause erosion and flooding on the Lynch property. And Lynch did what I like to think we in rural Ontario like to do, and that is he approached his neighbor and said, I got a problem here, how about we solve it? According to the court case, Lynch said Durbecker agreed. Durbecker denied that. Anyways, Lynch constructed a ditch across his property in order to deal with that collected water, and then it went across his neighbor's property as well. He went to collect a share of the cost from Durbecker, and Durbecker said, "I'm not paying. I solved my drainage problems. This is your problem." Lynch was furious, and he built a dam and stopped the flow of water from coming onto his property. So Durbecker actually initiated the lawsuit, and Lynch countersued. What the court determined, next slide please, is the first thing they did was review the definition of a natural water course, and they said, nah, it doesn't apply here. And then they looked at prescriptive rights, and they said the old original tile actually had a prescriptive right of drainage, but the new pipe that they put into the ground collecting drainage water, surface water, did not have a prescriptive right. And so Durbecker was found liable for damages. And the judge's order was Durbecker had to install a pipe. So instead of sharing in the cost of a ditch, Durbecker had to put a pipe in across Lynch's land. And once that pipe was put in, Lynch was ordered to remove the blockage, and then they had to pay damages of $6,400. And then I'm sure there was court costs as well. The interesting thing about this is that 20 years went by before it actually was resolved. Nothing happened. Nothing was changed. Lynch's dam stayed in place. Durbecker never installed the pipe. It got resolved when Lynch sold the property to a new property owner, and Durbecker approached the new owner and said, "You have any problem if we open up this dam?" And finally the new owner said, "Yeah, no problem. There's a ditch there already." So it was finally resolved. The point in telling you that story is common law is, these are the rules that we're dealing with, but it is the worst way of trying to solve drainage problems. There's got to be a more effective way. Next slide, please. This is just a slide I created to kind of summarize in one slide what I just talked about. The definition or the dividing line is the definition of natural water course in the middle, the red text. And on the right is the surface water rules, no right of drainage, lower landowner can block flow, there's a liability if collected, and there may be a prescriptive right of drainage. And then on the left-hand side are the rules around natural water courses. Water has to be permitted to flow. You can't block a natural water course. Riparian owners have a right of drainage and the right to use water, and then there's potential liability. So that's it in a nutshell. Again, none of this has anything to do with the Drainage Act, but it kind of gives you the rules that we're dealing with when we're dealing with water in in Ontario. These are the rules that apply. And because of the limitations of some of these things, this is the reason why we needed to have some sort of a mechanism, something to override some of these principles of the Drainage Act. Next slide, please. So common law is a barrier to solving drainage problems in a communal or collaborative way. Yes.
Okay, so before you get into the actual Drainage Act aspect, is there any questions with regards to the previous slides to Mr. Van Reen? So again, this is common law and statute law regarding to natural water courses and surface water. Councillor Meadows?
Yeah, I was just curious.
Yes.
That has
No, so let's say a property owner sues the municipality because they're collecting water and directing it onto their property. And you or the road supervisor says, no, we have a prescriptive right of drainage. That doesn't stop them from suing. That also doesn't grant you, the fact that the road supervisor says that I have a prescriptive right of drainage doesn't actually mean anything. It would have to actually go through court in order to prove that, Your Honor, this has been there for 20 years. When did you build the road and when did you put in the crossing? We did that in the 1960s, and therefore we have proof that it's been long uninterrupted use of or collection of water directing it onto the lower property owner. No, it would not be considered a municipal drain, but, and forgive me, this is where I get a little weak, but this is where the Planning Act and Municipal Act would potentially come into play. So if it was a municipal drain, I could tell you the answer, but because it's under different laws, the status of that backyard swale and the drainage, it wouldn't be necessarily common law, but I'm not sure exactly how the statute law would apply.
Thank you very much. What about our ditching system? Would that be considered a municipal drain or no?
Are you talking roadside ditches?
Yes.
There are some parts of the province where a lot of the a lot of the roadside ditches are municipal drains. There's very few in Adjala-Tosorontio that I'm aware of that are municipal drains. They are essentially private ditches. And private ditches, you can tell I shortened this from what you've heard before, but private ditches are private. A roadside ditch, no one actually has the right to drain into it other than a road. The roadside ditch was built for road purposes. And property owners, adjacent property owners may say, why don't you dig out the roadside ditch in order to make it better serve me? Well, that's not the objective of the roadside ditch. The objective is to provide drainage for the road. Now, the reverse also works. If a farmer has a private ditch on his property and the road says, oh, this is great, we can do some road ditching and direct it into the farmer's private ditch. Well, no, that's a private drainage system. You mentioned municipal drains. In order for it to be a municipal drain, there has to be a bylaw adopting an engineer's report that establishes the legal framework for that particular municipal drain. So it's a different system than the common law.
Supplemental?
Sure.
Down the 7th concession, you know where the 7th is. We have several municipal drains down that end of the municipality, and a lot of them drain into the municipal drains. And you get farmers who put in their water systems. They connect their water systems through our drainage system. Is that legal? Like, is that not infringing in on our drainage situation in the township? Like, you're getting less water through the pipe that it was designed for?
So I'm just looking to clarify. So you're talking about a irrigation piping system going through our roadside ditches?
Ditching system, correct.
Okay.
Yeah.
An irrigation system taking water from?
No, what I'm talking about is they put their irrigation piping. Let's say they're drawing from a pond way down on another piece of property they owned, and they pipe the water through our culverts. Okay. Now those culverts are allowing a certain capacity of water to flow through, yet they all have their irrigation piping going through our culvert system. So if there's a flash flood or whatever, is that not a liability on us because we've allowed it? I'm just asking hypothetically, because they're all going into a municipal drain. All these pipes are going, or our ditching system's going to a municipal drain, yet we have all these obstructions that we've allowed in our culverts.
So I thank you. I understand the question now. I'm going to hold off on that one when we get into municipal drain management.
Okay.
Then I'll talk a little bit about enforcing blockages on municipal drains and also, obstructions and damages to municipal drains.
Sorry, I thought that was part of here, but because you were talking about beaver dams and stuff like that, the blockages on our systems. So
Yeah.
I apologize for that.
If I understood it though, you're talking about blockages in existing municipal drains constructed under the Drainage Act.
That's correct.
Then the Drainage Act provisions govern in terms of management of the drain. So I'll hold that question.
Okay, thank you.
I know it's a wee bit off topic, but I'm just looking to our CAO. just on the question of a subdivision, swale in backyards, et cetera, that would be covered under a subdivision agreement and a purchase agreement for the landowner, I believe. But if you could just clarify that, how that would be approached by the municipality.
Through your worship, that is correct. It is enforced and constructed under that, and the engineering that goes with the subdivision agreement. It is all often in the purchase and sale agreement about the obstructions, and that any of those swales, drains cannot be obstructed.
Okay, thank you. Councillor Cox.
Through the chair, you mentioned about private drainage on agricultural lands. So if there was a private drainage that abutted a neighborhood, it's been there for a long time, would the farmer be responsible to maintain that private drainage system?
Through you, Mayor Anderson, if the private drainage system you're talking about is a ditch, is that what you're talking about? My opinion, the farmer has zero responsibility to manage it on behalf of anybody else. That ditch is there for their purposes. And so if it happens to serve others, great, but there's no obligation. It's not municipal infrastructure. So some of these questions that you're talking about identify or emphasize the reason why these private drainage systems are not necessarily serve the better purpose of the whole community of property owners. And so, yeah, somebody may want the farmer to clean out the ditch. Does he have to? No. Should he? He might, but he's going to go, well, you want this cleaned out. Why should I have to pay to have it cleaned out? So it gets into cost sharing as a problem then too.
So would they, if let's say the ditch filled in and that surface water flooded the adjacent properties, would then they be liable at that point?
Through you, Mayor Anderson, great question. I do not pretend to know all the mind of courts. It could very well be, but the farmer could say, this is my ditch. They don't have any right of drainage into my ditch in the first place unless they could prove a prescriptive right of drainage. And if they could, and then they might be able to make a case, but the judge might also say, well, you have a prescriptive right of drainage. You are allowed to go onto the farmer's property to clean out the ditch yourself. So I don't know the answer for sure, but there's different angles to it.
Just for clarifications, if the field itself was flooding and that came onto the residential properties and there was a ditch there, would then the landowner, like the farmer, be liable?
Potentially, I don't know of a court case of that specific situation, so I can't. The only way I can answer some of these common law questions is if I have a case that I can refer to. So I don't know. I can guess, but that's not going to be of a whole lot of value to you.
Thank you. One more supplementary question. But the landowners would be allowed to like block or berm up the back of their property that abutted that ditch, according to what's presented here.
Yes, the property owners don't have to accept surface water. I've dealt with many property owners over the years who have considered doing that, and I have reminded them, be careful if you do that. What's the reaction from your upstream neighbors? They may end up, first of all, suing you. You might be right, but it might be costly to prove that you're right. Number two, what other recourse do they have? They could petition for a municipal drain, and that could be forced across your property, and you'd be forced to contribute towards it. So there may be rights, but there might be also reciprocal rights.
Okay, thank you. Any other questions before we get into the Drainage Act? All right.
Next slide, please. Next one, thanks. So the objective, so the Drainage Act was passed because common law, the drainage rules under common law weren't working very well, and they needed some sort of a mechanism to provide a means of achieving communal drainage solutions that overrode the common law limitations. And there's two alternatives provided under the Drainage Act. The first is mutual agreement drains, which are basically a contract between owners that are registered on property title. I'm not going to deal with them today. The second one is petition or municipal drains, which I want to talk about. Can you advance it 2 slides? So petition drains, so the Drainage Act was established actually early in the 1800s. So they realized, actually before we became a country, it was established in Ontario. And they realized that in a province that gets an abundance of precipitation, we need some sort of a mechanism. By the way, it's not existing exactly the same as it did in the 1800s. It's been updated many times. But what the Act says is we're going to give property owners that are experiencing drainage problems the right to petition to resolve those problems, because we'd prefer that they use this mechanism rather than blocking surface water or taking neighbors to court and that sort of thing. Ineffective way of dealing with drainage. So it's all based on this petition. The petition is a legal document that is prescribed by the regulations, and the property owners or road authorities that sign the petition form become financially responsible as soon as they sign it and submit it to the municipality. It's the use of the Drainage Act is not restricted to agricultural areas. That's a question that I commonly got. No, it can be used elsewhere. It does tend to be more controversial simply because farmers tend to understand that I have to pay for my drainage, whereas other property owners less so. In the petition drain process, when establishing a brand new municipal drain, my recommendation always to council is be impartial. There are those that want it, and there are those that are going to be opposed to it. Be like the referee in the hockey game. You're impartial administering the rules. Don't necessarily take a side. Next slide, please. There's 4 things that make a valid petition. So if that yellow area is the area requiring drainage, the problem area, what the Act says is it has to be signed by one of the 4 things listed on the right-hand side. The majority of the owners in the area requiring drainage. So this yellow area, it's the problem area. Under common law, they might be able to sue their neighbor because they've directed water onto them or put up berms or dikes and that sort of thing. This is the alternative for them. We are going to sign a petition, and as long as it's signed by the majority in number of owners, and in this example, there is 1, 2, 3, 4, 5, 6, 7. So as long as it's signed by 4 out of the 7, it meets the criteria. Or the owners that represent at least 60% of the land in that problem area, the area requiring drainage. And if the road authority needs drainage, then the road authority can sign a petition. And then finally, the director, who is a director under the Agriculture, Food and Agribusiness, the ministry of that ministry, has the authority to sign the petition as well. And that's what makes a valid petition. And that valid petition triggers the rest of the Drainage Act process under the that I'm going to be describing. No valid petition, no process. So this is the legal framework on which the rest of the process is based. Next slide, please. Council then considers the petition. You have the right to reject a petition, but you have to have a valid reason, because petitioners can appeal to an appeal body called the Agriculture, Food and Rural Affairs Appeal Body, and they'll be going, why? If these people have drainage problems, why are you standing in the way of this and trying to resolve it? The only good example that I've been able to come up with is if your official plan protects environmentally sensitive land like wetlands, and somebody's petitioning to drain the wetland, say no. It's still appealable, but you can say, hey, this is the reason why we said no. The copy of the decision and the council's decision and the copy of the petition is then circulated to the petitioners, the local CA, and other municipalities that might be affected, band councils and so on. And there's a few recommendations on who else to send it to. Next slide, please. Council then appoints an engineer, and there's a section in the act that says the engineer must be fair and impartial, representing the whole watershed, not just the petitioners, not just the municipality. They have to be fair and impartial, representing the community of landowners. And so there's a section in the act on that. The engineer gets appointed by bylaw resolution because of property rights, which are important, but the appointment by bylaw resolution allows the engineer enter onto private land to survey, to design, because most of these drainage systems are located on primarily private land. Next slide, please. The next step in the process is an on-site meeting. This is done by the engineer inviting the property owners, and the act says to the owners in the area requiring drainage. We usually encourage more people to be invited. Each public utility or road authority, we also recommend that the engineer invite conservation authorities and fisheries and oceans representatives, get the regulatory agencies involved as well. At this meeting, the engineer is the one that has to determine if the petition is valid. And then they also collect information from the property owners on what's the issues that we're trying to solve. Next slide, please. There's a preliminary report, which is an optional step in the process, allows the municipality or the engineer to explore different options for resolving it. And then there's a meeting to consider the preliminary report. And at this meeting, you can either decide we're going to go ahead and we're going to go ahead with this option, or no, we've decided that we don't want to go ahead anymore. We're going to stop the process. And council does, if council does that, then council pays the costs incurred to date. If the petitioners decide by removing their names from the petition, then the original petitioners are the ones that pay the costs incurred to date. Assuming it goes ahead, next slide, please. Yes.
Just a question on that, because in the previous slide, when you accept the petition, council has a reason, you have to have a very valid reason why you're not accepting a petition.
Right.
If you go through a preliminary report process, does there have to be a valid reason, or is it just a consensus that the drainage is no longer required there, or how does that work?
Great question, and one that I glossed over. There are some aspects of this. So if the example I've used in the past, if it's $1 million project to improve the drainage of 10 acres of land, you can quickly determine that, hey, this isn't practical anymore, and we don't feel like we're doing our job as council if we're forcing this on property owners, even if the main petitioner wants to have that drain continue on. That might be grounds for saying no in a case like that. You've done some investigation, you have some rough cost estimates, and you know what the area requiring drainage is because the engineer has defined it. So that might be the basis for potentially saying no if you had, you as council had identified that a preliminary report was required.
Thank you.
So assuming that it gets past the preliminary report, then the engineer does a field survey. And again, if you look at your municipal drains, there's parts of it that are on your road authority, but the vast majority of them are actually located on private land. So the engineer has the right of entry onto land, and they will go and record elevation. So they'll survey, they'll identify drainage features like culverts, tile outlets, and they'll do some soils analysis, take a look at the soils, record other features. And it's an opportunity on a property owner by property owner basis to have a one-on-one with some of the property owners. It doesn't always happen, but if that's possible, then it's something that the engineer usually tries to take advantage of. Next slide, please. So then the engineer produces a final report. There are specific requirements in the Drainage Act for what needs to be in a report. There are other things that can be added, but there are some very specific items. I'm not going to read them all, but these are things that are specifically in the Drainage Act that must must be included in the engineer's report. A few other things, and this is a connection back to common law. In the bottom part of that box, it says, in developing the report, the engineer must take a drain to a sufficient outlet. And that term is defined in the act as a place where it's not going to do damage to somebody else. So we don't want the engineer to design a drain, build it, and put the municipality in a common law position of liability. So engineer, you're certifying that this is going to be taken to a sufficient outlet where it's not going to do damage to anybody else. You have to consider all the individual property owners' needs, but it's always a balancing act. One person will want one thing and another person will want another or not want it at all. And so they consider the individual property owners' needs, have to get permits and approvals, so it's subject to legislation. And usually they'll work with the drainage superintendent and other municipal staff to make sure that the report is set up to as the superintendent and the municipal staff want. So, and then on the left-hand side is a list of some of the things that a Drainage Act project may be subject to. Next slide, please. This is a very small drain that was that Tom Pridham did. The only reason I'm using it is because it's small. The hashed line is the watershed boundary. The line that goes diagonally across the property is the municipal drain. The two property owners, I'm not sure if you can read it on yours, but there's a fellow by the name of Matthews and another one, Martin. They both petitioned because they wanted to tile drain their land. And the fellow who was between them and the outlet absolutely refused for them to take a pipe or anything across their property. So they eventually ended up petitioning in order to make this into a municipal drain. And the drain is built now. But that's a typical little drainage plan. Next slide, please. The next slide is a profile. So most of this drain is a pipe. A little bit of the downstream section is a ditch municipal drain. So it identifies some of the features. Next slide, please. This is the assessment schedule for this particular drain. I'm going to get into later on when we do the quarter revision component of this, I'm going to get into assessment types and I'm going to talk about them a little bit more. So I'm going to burn past this right now, but it shows you that each of the property owners in the watershed of this particular drain are being assessed a share of the cost, as is the road being part of the watershed, so they also get assessed a share of the cost. Next slide, please. When a drain is built across someone's property, they are also entitled to allowances, which is the Act's term for compensation. So if you're using land on somebody's property to build a ditch and they lose an acre of land, they should be compensated for that acre of land. If you need a space along that drain in order to build the drain, they should be compensated for that. If you're going to damage crops or trees or anything else, they should be compensated for that. That compensation becomes part of the cost of the drainage system and is shared by the property owners in the watershed. So the community of landowners are buying the right to build the drain and have the drain maintained and managed in the future across these property owners' lands. And again, this is a table that was in that particular report for showing how property owners receive some compensation. Next slide, please. The next step is not mandatory. It's not in the Drainage Act, but it's common amongst just about all drainage engineering firms anymore. The engineer hosts, so it's the engineer calls a meeting with the property owners and says, here's what I got. Here's my preliminary information. I want some feedback. Quite often the first feedback is I'm being charged way too much. And then they'll get into the details of the report. Why did you put it there? Why is it this big? My allowances aren't enough. And the engineer then will use that feedback to finalize the report and then present it, finalize it, and submit it to the municipality. And then the municipality then has a meeting to consider the report. And in advance of this meeting, a copy of the report and a notice of the meeting is sent to all involved property owners, so everyone in the watershed of the drain, any other municipalities that might be affected. So there are drains that cross municipal boundaries or have parts of watersheds in other municipalities, so they get notified. Conservation authorities, Ministry of Northern Development Mines, well, that's now Ministry of Natural Resources, road authorities, public utilities, railways, and the Ministry of Agriculture and Food as well. So that's who gets invited. And then at this meeting to consider the report, next slide, please. The owners in the watershed, so this meeting to consider the report is chaired by head of council. And the engineer would start off by giving an overview of the project. The property owners that signed a petition, property owners in the area requiring drainage have the right to add or withdraw their names from the petition. After these changes, if it doesn't meet the criteria that I mentioned earlier, the project stops and the original petitioners pay the costs incurred to date. And then likewise, council can decide whether or not to proceed with the project. But if you decide not to, there is a right of appeal by the petitioners, and you have no ability to recover costs incurred to date. Yes. Sorry.
Through the chair. With regards to this, if what you're talking about, if you go to page 8, right? Let's say the largest part of the yellow on that map there. Okay.
Okay.
Largest part. We currently have a situation like very similar to this where you can see the dotted line through the road where a culvert's gone through. Let's say the township created that problem where water has been diverted onto somebody else's property and is now creating a problem where they have to have a municipal drain. Would their cost evaluation go down because it was the fault of what we did to create a problem or create something that didn't exist there before?
Great question. One of the things that people often want the Drainage Act to do, and the Act is really not set up to that. They want the Act to assess blame. And it really isn't a substitute for court. So if you as a property owner felt like there were property owners that caused me problems and now we're into this drain, in the meantime, you could do your own lawsuit and sue them. I know I passed over the assessment principles, but I'm going to talk about that later on. But there are sections in the Drainage Act that says, engineer, these are the principles you must use in order to levy out costs. And there's things like benefit, outlet liability, injuring liability. There's a special assessment to road authorities. Those are the principles that that the engineer has to use. And if they can't defend those principles, then they're extremely vulnerable when it comes to any sort of appeals. So the shorter answer to the question is no, not really. The engineer will base it on the situation that's there right now. If you were in a situation where a road authority actually created a problem, one of the things that the engineer might not say, but I'll tell you, if you feel that you're vulnerable, you may want to go to that property owner and say, we know that you're going to get assessed under the Drainage Act, but we're going to pay your assessment because we know that we created the problem. Don't ask the engineer to do that because you can't defend it before the tribunal based on the assessment principles in the Act.
Supplemental. So that means, like, if you're going to be assessed, you shouldn't sign the assessment if you're going to go through that route? Is that what you're saying? Or like if, I guess what I'm saying, I'm trying to get at is if we created the problem, wouldn't it be our responsibility to correct? Could our council override the assessment and say, we're going to, because we created the problem, we will pay for the problem?
That's what I was suggesting at the end. Don't ask the engineer to do that because the engineer is obligated to
follow the act.
the
And
act and the principles of the act. Otherwise, you can't defend it if it goes to before the appeal body.
so we as council can make that decision though.
There is
Provision.
I'm dealing with a council right now that are contemplating that very thing. They're involved in a municipal drain project. Well, there's multiple municipalities involved, but to some degree, they created the problem. And it's going to cost a lot, and they're contemplating whether or not they should actually just pay for the drain. My advice to them is, if you are doing that, because this isn't the first drainage project in Adjala-Tosorontio, and it probably won't be the last, have really good grounds that you can define why you're paying for it. Because if you don't do that, for the next project that comes along, they'll be going, excuse me, you paid for theirs, pay for ours too.
Right.
Right.
I
So-
understand, yeah.
But the key thing I want to emphasize is the engineer is bound by the assessment principles in the act and needs to adhere to those. Otherwise, they are extremely vulnerable when it comes to any sort of appeals before the tribunal.
Also, is there any way we can get a copy of the Complete Drainage Act?
Absolutely.
Yeah,
Can't have
I
mine.
would love
My
to have
name's
a-
on there.
yeah, I'd love to have a little book like that. So anyways, thank you.
Thank you. And I just wanted to follow up on that. So there's just kind of digging a bit deeper into this subject of, even though there might be an issue, for example, let's just take the same example where the municipality might have caused a problem. If we go if we petition for the Drainage Act and then there's a drain that's, on that person's property, for example, then they would be getting an allowance as
Yes.
well. So that allowance might actually supersede the expense. So they may be to a positive amount before a negative amount.
Yes. If I can get you to turn back to the assessment schedule, it was slide 24. If you look at the fellow at the bottom end, sorry, so looking at the watershed again, and it is the fellow right at the bottom end who refused to allow the drain to go across his property in the first place, Adjala. If you look at the assessment schedule, this fellow isn't assessed. Why? Because he actually doesn't benefit from the drain and he's not putting any water into the drain. But when you look at the allowance slide, Adjala is getting a total of $2,700 in allowances. So in that case, Mr. Everlay or Miss Everlay is actually receiving compensation from the community of landowners for that drainage system. So absolutely. There might be situations where somebody doesn't actually benefit from the drain or doesn't contribute water into it and therefore gets no assessment or minimal assessments, and their allowances exceed the assessments.
Okay, thank you. Councillor Simpson?
Through the chair. How is the benefit determined?
Can you hold on to that one? Because I have a whole section in the quarter revision training that I would like to cover on assessments.
All right, so I believe we were at the finalizing the report, meeting to consider, and then the appeals.
Right. So the final role of council, just to make sure that the final role of council on the previous slide was to, if you agree that this project should proceed, you give 2 readings to a bylaw that provisionally adopts the report. From my perspective, that means council agrees in principle with the report, but it's subject to the appeals. And the appeals process may actually modify the report. So now that brings you to the next slide, please. There are 3 appeal bodies. The first one is called the Quarter Revision. And we're going to deal with this far more later on. So I'm just going to breeze through this for right now. The role of the Quarter Revision is to hear appeals on assessments. Whoever set up the legislation realized that the biggest complaint about Drainage Act projects is my share of the cost. I'm being assessed way too high. So they set up an appeal body that's locally based to hear those types of appeals. The second appeal body is called the tribunal, and they are a provincial appeal body. The full name is actually the Ministry of Agriculture, Food and Rural Affairs Appeal Tribunal, and they hear appeals under a dozen pieces of different legislation. Drainage Act is one of the major ones. So they hear appeals from the decision of the Court of Revision, but they also hear technical appeals. My allowance is too high, or my allowance is too low, or I don't like where the engineer located the drain, and or all those sorts of things. The third appeal body is called the referee. Even though the strange name, the referee actually has powers equivalent to a justice of the Superior Court. So they have they have the authority to order somebody to. They kill the project. They have the authority to make changes to the project. They have the authority to order damages to be paid. So now most of the referee hearings are actually held virtually now. They used to be held in the local courthouse, but now they're held virtually. So that's the three different appeal bodies. Next slide, please. After all the appeals have been dealt with, so you got the meeting to consider provisional adoption of the report, then you go through all the appeal stage, and if there's lots of legal appeals, that could be several years. That's the exception rather than the rule, but it could be several years. But once all the appeals have been dealt with, then council can give third and final reading to the amended bylaw adopting the report, and that authorizes the construction of the drain, even across properties that might have been opposed to the project. You got to go through a procurement process for the retention of a contractor. It also authorizes the levying of costs to the lands within the watershed, and it creates new municipal infrastructure. Then at that point becomes a municipal drain. Municipal drain doesn't exist without a report adopted by bylaw. The bylaw is the law for that particular drain. Next slide, please. This is just a slide that I created to try to summarize, to show you in one slide a summary of the petition drain process. So nothing new here. It's just a one slide summary. Okay, so now the drain has been constructed. What I didn't include in there is you would levy the costs, you would apply for any grants that might be available through the Ministry of Agriculture, Food and Rural Affairs. And yeah, and again, levy out the net of costs to the property owners. By the way, there's a section in the Act that says the assessments under the Drainage Act have the same status as property taxes. So there's a whole chain of court cases, referee decisions on a property owner in Northern Ontario who decided not to pay his drainage assessments. And eventually his property was put up for sale and he was evicted, and he lost his property because he refused to pay about a $10,000 drainage assessment. So it has the same status as property taxes. Okay, management of municipal drains. And again, not a whole lot of slides on this one. Once it becomes part municipal infrastructure, so once that bylaw is passed and the drain is constructed, it becomes municipal infrastructure. And yes, it's municipal infrastructure that's maybe primarily located on private land, but the municipality, with the payment of those allowances, acquires a right-of-way to enter onto the land to not only construct the drain, but also for any future maintenance or repair of that drainage system as well. So it becomes your infrastructure. It's your responsibility to manage. Some of the responsibilities include maintenance and repair. So repair is restoring the drain to its original design. So the plans and profiles and specifications in the report. You have the right to make improvements to existing drains. You can do assessment schedule updates. You can manage connections. So if somebody says, oh, you got a nice drain there, I'd like to take my land that's not in the watershed of this drain and connect it to the drain, you have the right to say, no, you can't do that. You weren't part of the community. You can't buy in now afterwards. You also have the ability to enforce. So back to your question, Councillor Meadows, one of the enforcement sections says you aren't allowed to block a municipal drain. And if you do, council can remove the blockage and charge you the cost, charge that particular property owner the cost of the removal of the obstruction. So if somebody's blocking a culvert, you have enforcement capabilities under the Drainage Act. I've never heard the example of an irrigation line being used as an enforcement tool, but would it be a blockage? I'm assuming if it's an irrigation line like that and the culverts like that, that's significant. So yes, it definitely could be used in a situation like that. More typically is somebody's got a ditch municipal drain across their property and they go, yeah, I'd like this to be a pipe because I'd like to farm the whole area. And so they stick in a pipe this size and they cover it all up. Well, that's a blockage of an existing municipal drain, and you can order that to be removed. And if they don't remove it themselves, you can do it and charge the cost to them. So that's Section 80 of the Drainage Act.
If I might, Councillor Meadows, I'm just going to get through this quick section, and because we got the court revision to do as well.
Okay. You can abandon a municipal drain. There's a process for that, but just be careful. Once the drain is abandoned, you revert to common law, and so then you are into lawsuits to resolve drainage issues. Next slide, please. So the only other thing I'm going to say about management is you have a drainage superintendent appointed to manage the drains on the municipality's behalf. And so again, that's done by bylaw, provides access to land. Normally it's an individual appointed, occasionally a company, as you have done. Superintendent's duties: maintain and repair municipal drains, and really the superintendent manages the drains on behalf of council, but also provide council and staff with advice. So when it comes to common law, why am I here? I'm here because your drainage superintendent preferred me to do the training rather than him. So provide property owners with advice on how to deal with common law drainage issues as well. Next slide, and then that's a summary. It's a tool to solve drainage problems. It's municipally administered. It's a professional design by an independent party, an independent engineer. There's an assurance that there's going to be compliance with applicable legislation, which is not always the case with some of the private solutions that happen out there. There's independent appeal bodies, and you have the ability to recover costs. You have an ability to access private land to construct the drainage system, and also for maintenance and repair. So it tries to address the limitations of the common law with a system that results in a municipally managed drainage system. Okay. Now, quarter revision. This is what I'm going to be talking about: description, authority, composition, assessment review, grounds for appeal, filing appeals, and a suggested hearing process, and then some decisions. Okay, next slide, please. Description. I can't emphasize this enough. Quarter revision is not a committee of council. They may be appointed by council, but they are an independent appeal body making independent decisions. I'll give you an example. I was at a quarter revision where they referred to each other as Councillor Anderson, Councillor Meadows, and so on. And I'm going, no, you're not serving as council members here. You are an independent appeal body. So I want to emphasize that's your role. You're taking, if you are appointed as a quarter revision member, you're taking your council hat on and you're putting your appeal body hat on. You're appointed by council, but it's not a committee of council. You don't report to council. Council can't change a quarter revision's decision, so it's not something that has to be sent to council for approval. It's considered a tribunal under the Statutory Powers Procedure Act, and I included a definition on the left-hand side. And it's comparable to the Ontario Land Tribunal or the Agriculture, Food and Rural Affairs Appeal Tribunal in terms of legal status. Okay, next slide, please. What's their job? Their authority, their responsibility is to hear assessment appeals on new drains or drain improvement projects or new assessment schedules. What's the composition of the Court of Revision? It is made up of 3 or 5 members appointed by council. When there's other municipalities involved, 2 from the initiating, 1 from each other one that might be involved. What is the eligibility criteria? You have to be eligible to be elected to council. Now, what advice can I give you? My advice to you would be appoint somebody who has some familiarity with the Drainage Act. And I'm not suggesting that you do this, but council might be in the best position, or council members might be in the best position to serve as Court of Revision, as long as you remember to take one hat off and put the other one on. There is a complete exemption, or the Municipal Conflict of Interest Act does not apply to activities under the Drainage Act. So you don't have to declare a conflict of interest. However, if you are an assessed owner on a drain, it's not a good look. So I would recommend that you don't serve on a Court of Revision on a drainage project on which you're assessed, just for the look to the public. Oh yeah, you're involved in this decision making and you're assessed yourself. Not a good look. Okay, next slide, please. Types of assessment. And I think I have an individual slide. Yeah, so these are the different types of assessments that are instructed in the Drainage Act for the engineer to calculate. So let's take a look at each one of these individually. Next slide, please. Okay, there is actually a bottom part to that one too. Okay, so first of all, the Act defines what benefit is. And I'm not going to read the whole thing, but it basically says you get assessed benefit if the drain will actually benefit your property. I've dealt with property owners who say, you're building this drain and I have no intention of using it, so I shouldn't be assessed for benefit. And my response to that is it's a benefit to the land, not to the landowner. So if somebody gets a new drain and they don't intend to use it, but they sell their property later on and the new owner says, great, I got a municipal drain, I can tile my land and outlet it right here. It's a benefit to the land as opposed to the property owner. The best way, and I think Councillor Meadows, you had this question, the best way I can describe how benefit is calculated, there's a neater formula. Engineers like formulas. There's a neater formula for outlet liability. It's not nearly as black and white for a benefit assessments. But who would actually get a benefit assessment? Those who actually derive a benefit. We try to put an estimate on what that benefit would be. How much would the property value increase if we build this drain? And then you total it up based on all the properties that are getting a benefit, and you go, okay, it's going to benefit by a total of 1 million, but our benefit assessment proportion is 400,000, so we'll make 40% of each of the benefit assessments on every one of those properties. So again, it's still a gut feel, but it's one that the engineer has to be able to stand up before the Court of Revision and later on to the tribunal and be able to defend. So again, it's not a black and white. I showed you earlier an engineer's guide for working under the Drainage Act, and it spends some time in there on how to calculate the benefit assessments or things to take into consideration. So that's the best I can give you for benefit assessments. Okay, next slide, please. And I covered some of these things already, this benefit assessment. So yeah, it's usually applied to the lands adjacent to the drainage system because they're going to get some sort of resolution of a drainage problem. And again, it doesn't have to benefit the current owner. It has to benefit the current property. Next slide, please. Outlet liability assessment. And the first thing I'm going to talk about is the term liability. Why did they include that in there? Well, this is a connection back to common law. Under common law, surface water has no right of drainage, and if you collect water and dump it onto somebody else, you could be held liable for damages. Plus, Lower property owner doesn't have to accept that water. So when an engineer designs a drain, a good share of the cost is assessed to the property owners that actually derive a benefit. But when they design the drain, and let's say it's a 3-foot diameter pipe, if you picture this section of the pipe is to accommodate the water from that property up there. This part of the pipe is to accommodate the water. So everybody really, the water generated off of your property, which under common law has no right of drainage, it's now being accommodated by this municipal drain. And that gives you the right to have your water in the drain. It overrides the common law by paying this outlet liability assessment. Not every property or not every acre of land is the same under outlet liability. We usually use an acre of agricultural land as the basis, as the benchmark. And then an acre of road might be assessed at 4 times the rate of an agricultural property. If it's wetland or bush, it might be half of the agricultural rate. If it's residential, it might be 2 times. That's the sort of principle that is used. Now, that's really oversimplification, but that's the principles that are used in terms of determining outlet liability. Any question on those two? Those are the 2 main ones that are under the Drainage Act. Okay, next slide, please. Injury liability is very similar to the outlet liability assessments. And in fact, it used to get used quite regularly. It's gotten to the point that it's not used at all anymore. The calculation for injury and liability is exactly the same as outlet liability. And the appeal bodies over the years have recognized that why are we doing this 2 different ways to come to the same solution? So now you'll see most reports, they just put everything under the column of injury, outlet liability assessments. But there is the principle still there that if water is directed onto somebody else causing injury, it could be assessed for injury and liability. But then the calculation is exactly the same as outlet liability. So again, doesn't get distinguished. Next one, next slide, please. So here's the basis for assessment on both outlet and injury and liability. Based on the volume and rate of flow of water artificially caused to flow upon the injured lands or roads. So again, because the basis is the same, they don't distinguish. Next slide, please. And some of this is I've already covered. So you may have somebody that the drain isn't near, they don't benefit from the drain, and they may come to the Court of Revision and they'll go, I don't benefit from this drain, why should I have to pay to fix their problem? The answer to that is under common law, your water, which is flowing downhill, under common law, it doesn't have that right. But by paying this outlet liability assessment, you're buying the right to have your drain water in that drain. So it's overriding the common law. It's a difficult concept to actually pass on, but that's the basis for it. It's the Act says when you're designing a drain, who should you accommodate for? The whole watershed, obviously. And if you're part of that watershed then and contributing water to that drain, then you are going to be assessed financially as well. Yes.
To the chair. Sid, so is there a different rate? Like say, this guy's right here putting water into the drainage ditch, but you got another guy who's maybe 4 or 5 properties farther back, but he's still contributing. Does his rate, does he have a reduced rate compared to this guy right at the?
Thank you. Yes, I do understand your question. And if anything, they would have an increased rate. And the reason why, the person further away uses the full length of the drain, whereas somebody, let's say it's a person at the bottom end of the drain. Their water goes into the drain, but they only use the bottom end of the drainage system. So they would only pay outlet liability on the share of the cost of the bottom end. But if you're water is using the full length of the drain, you will be paying a share, smaller proportion, but maybe it might be overall a larger total sum because your water is being using the full length of the drain.
For the more you use, the more you pay.
Actually,
Simplify that.
my question basically wasn't on that. I understand that concept, but my question was based on the fact that if you had 100 acres here, and then you got like a hill, and you got 100 acres that's maybe 4 or 5 properties farther up, but their 100 acres, his 100 acres is roughly the same as this guy's down here on the drainage ditch. Is his a reduced rate up here at the top? Or because at the bottom, it's an accumulation of these 5 properties, right?
So again, so keep in mind that 100 acres at the bottom end is probably being assessed for benefit because the drain's going to provide immediate relief to that particular property. But their outlet is probably going to be smaller because they only use the very bottom end of the drain, whereas the drain that's up on the 100 acres up on the hill that's further away, their water still drains, it's getting there, but it's using the full length. So you need to look at the overall picture. You can't look at just outlet liability and say, okay, why am I getting paid more? It's also taking into consideration the benefit assessment. So the guys that actually benefit from the drain, they will get their individual benefit assessments, and the guy up on the hill won't get that benefit assessment. So it's a combination of the two.
So in theory, then, as Councillor O'Leary indicated, an individual further away from the drain uphill would probably pay less total assessment
Oh,
than
absolutely.
somebody down at the bottom of the hill with the same property type, et cetera.
Absolutely. Yes.
Councillor Meadows?
Yeah, through the chair. So let's say you have the outlet at the bottom of the hill and you got the 100-acre farm, like Ron said, up at the top of the hill. The bottom of the hill is maybe 3 or 4 acres and the other guy's up at the top of the hill, 100 acres. And he tiles his farm and tiles it all into the municipal drain and floods the guy at the bottom where the outflow location is. Is there an outlet liability there?
Okay, so the 100 acres, first question I have, I feel the need to draw.
Sorry.
If the 100 acres is all within that watershed of the drain,
Yeah, it's all in the watershed.
then the engineer would be assuming that that 100 acres is going to tile eventually at some point and be able to connect to the drain. That's not the issue. The drain should be sized to take that water from that 100 acres. What's a greater concern is if the 100 acres, only 50 of it is actually in the watershed of the drain, and the other 50. So here, right, we'll use an exaggerated, but let's assume that 100 acres is straddled right on top of a knoll. 50 acres is within the watershed and drains that way, but he gets a contractor and the contractor says, I can bring it all that way. Number one, that's wrong. Number two, they have to have permission from council to be able to make that connection. Number three, I actually think, although it's never, I'm not aware of it being tested, you could probably order them to disconnect from the drain. It's not clear under the Drainage Act, and you might have to go through and get a court order for something like that. But if the 100 acres, again, back to the knoll, if the 100 acres is all within the drain, the engineer should have sized that drain to accommodate that water. And if he tiles his land and connects to the drain, I see no issue. I do see an issue if that 100 acres, that's all within the watershed, decides to develop and they're now a residential subdivision with increased runoff. So something like that might be 3 times the rate. We might think of it as 3 times the rate. Number one, the drain wasn't designed for that changed land use. Number two, you need to be assessed at a higher rate because even if the drain could accommodate it, you're contributing more and your share of the cost should be more. And that's some of the management sections that I glossed over really quickly earlier.
Supplemental. I just have one more question with regards to that. Like a stormwater management pond in a residential area, and it flows into like a river system or whatever. Does that section that goes into the outflow of a river or stream or whatever, does that outflow part now become a municipal drain, or does it just, it's just a natural course now?
There are many municipal drains that the engineer says my sufficient outlet is this natural water course. And that doesn't make that natural water course a municipal drain. You got to go back to the report. So if I can refer back to the slides, I included a sample plan and profile. So slide 22 is the plan, and the profile was on slide 23, and
Right.
and that's what defines a municipal drain. So Tom, when he did this report, defined that bottom end of the that drain as the sufficient outlet. It actually went into a natural water course, if I'm not mistaken. The natural water course is not part of the drain. It's only the part that's defined on the plan and shown in the profile.
So the small portion, that's like the outlet, would be that small portion. If it's got to go down
Right.
into another area, that would be classified as a municipal drain, that the municipality would have to make sure it's functioning.
Okay, I'm gonna ask you to go back to slide 22 with the plan.
Oh, okay.
Thank you. I'm gonna briefly. This example, this is the municipal.
Oh, okay.
This is the bottom end, this is pitch, this is all pipe. That from the front. This is a natural water course. It is not the municipal. Tom decided that this is an outlet. It's not going to do damage to anybody else. I wanted to make sure that you're clear that.
Okay, thank you.
It is not a municipal drain.
Okay, thank you.
Okay, I think we are on slide 44. Oh, a little too far, I think. There, perfect. Some of this I covered already because the principles of outlet and injury liability are the same and accepted by the appeal bodies. You usually will not see them distinguished. It'll all come under the lumps column of outlet liability. And again, some of the lands that contribute water to the drain can be assessed for outlet liability, but they may not be assessed for benefit, and some could be assessed for both. The lands at the bottom of the drain that actually derive a benefit and are contributing water into it. Next slide. Special benefit. It doesn't get used a whole lot. Sometimes people want things as part of a drain that really aren't needed by the drain, not needed by the community, but the property owner wants it. So if you think of a channel or ditch municipal drain, the act says, well, you got to provide that property owner with a crossing so that they can access their land. But if the property owner says, I want 2 or 3 crossings, the first one is cost shared. The second one and the third one, I would consider to be a special benefit. You want that? You pay for it. So that's an example of special benefit. Any additional work or feature that has no effect on the functioning of the drainage works. There are other examples, but I won't get into them. But next slide, please. Section 26 is the last major special assessment type, and this one affects roads. What the Act says is roads and public utilities have a special responsibility. When a drain comes along and it has to cross a road, what the Act says is the community of landowners is responsible for the cost of the drain, pretending that the road wasn't there. What would you be doing? Be building 66 feet of channel. Or if it's a pipe, 66 feet of pipe. But because you need to put in a culvert and you need to backfill it and you need to compact it and surface treatment and end treatments and all this additional costs, what this section of the Act says, all the additional costs caused by the existence of the road or public utility are to be paid for by the road or public utility. So as a result, a road crossing quite often is paid 90% or not more by the municipality. And not just the municipality, MTO, there are lots of drains that affect MTO right-of-ways, and they would be assessed as well. I don't know if you're familiar with, in keeping on track of AMO's concerns about railways. The railways are saying we're federally chartered and we don't have to pay this Section 26 assessment because we don't have to comply with the Drainage Act. And there are lawsuits that are going on right now about how the federal government, just because they are federal or federally chartered, they are still bound by this. They're trying to get out of having to pay the increased costs, which if they don't have to pay it, then becomes a cost to the property owners. And you can imagine the cost of a railway crossing added to the cost of a drainage project, it would be significant. So lawsuits going on that one. Okay, next slide, please. So the road authority means the road, public utility, it means gas, waterworks, and railways under that definition as well. So that's where the two are covered. Next slide, please. Grounds for appeal. So if you serve as Court of Revision member, there are 3 grounds for appeal. You may hear all sorts of things. But in your mind, what you need to do is make sure that, does it fall into one of these 3 grounds? If not, we probably don't have the authority to hear it. So first one, any land or road that has been assessed amount that is too high or too low. And again, usually it is, I'm assessed too high, somebody else is assessed too low, although I've heard the other way around once before. It was the exception. Now, why might they think that? Again, sometimes it's an upstream landowner who says, why do I have to pay to fix Ron's problem or whatever it may happen to be? You know, they don't realize the outlet liability assessment. So just because they complain doesn't mean that they shouldn't be assessed. Another one that they might not understand because they'll compare to their neighbors' assessments. Not all properties are assessed the same area based on the watershed delineation. So you might have a property that's 50 acres in the watershed and your neighbor, same size property, but he only has 25 acres. They're going to be different assessments. So it's not necessarily apples to apples just because you both own 100-acre parcels of land. So that's ground number 1. Ground number 2, next slide, please, is any road or land or road that should have been assessed has not been assessed. So it's less of an issue now because we have some great data. LIDAR really helps us to define watersheds quite easily. But there used to be times that you would, the engineer might miss actually a watershed or a section of land that went into the drain that should have been contributing as well. So that would be the basis for this type of assessment. So if there are lands that the engineer has not assessed and should have been, then that's a grounds for appeal as well. And now the engineer might say, well, I totally missed that. And therefore, could you allow me to come up with a different number, develop a different watershed and or expand the watershed and adjust the assessments accordingly. Third grounds for appeal, next slide, please, is due consideration has not been given to the use being made of the land. So this is back to what I was telling you before. An acre of agricultural land is assessed differently or less than an acre of road or an acre of parking lot or even an acre of bush or swamp. They would be assessed at lower rates. And if the engineer hasn't given proper consideration to that, it will affect the outlet liability assessment. So they would have to come forward with, here's the reason why I think that the engineer hasn't properly considered my land use. So those are the three grounds for appeal. So filing of appeals. So after you have the meeting to consider the report and you send out the notice of the Court of Revision, they have the Court of Revision has to be held within 20 to 30 days afterwards. So make it nice and easy. Let's say you send out a notice of the Court of Revision and the provisional bylaw, you send it out on January 1st. Somewhere between January 20th and January 30th, the Court of Revision has to be held. And the appeals, so let's pick January 25. Appeals have to be filed a minimum of 10 days before, so that's January 15th. So that gives the property owners 15 days to review the report, look at their assessments, and decide if it's something that they want to appeal. So, and the reason why I ask that is, or I emphasize that is, you, as the Court of Revision, you have the right to accept late appeals if you so choose as a court. Suggested hearing process, next slide. So you might have an agenda that says, here's my opening and then some housekeeping events and then a list of appeals. So if you had 5 property owners appealing that have filed appeals, then you can list them all individually. Ask the clerk to identify appeals that were filed within the proper timelines and appeals that were filed late. And also you might ask if anybody wants to submit a verbal appeal, but then you have to decide whether or not you're going to accept it. You could say no. It puts the engineer in an awkward spot because the appeals filed in advance gives the engineer time to look at this and examine it and provide evidence to the court to say, here's how we dealt with this. Verbal appeals late, kind of, now you're trying to deal with it on the spot and look at my records and my calculations that I did or whatever, but that's the engineer's problem. So doesn't mean that you can't accept them. Okay, next slide, please. A schedule of appeal is created. The engineer has to give an overview of the assessment principles first. So they'll talk about what I assess for benefit versus outlet, how I split that. I assessed 40% benefit and 60% outlet, and I divided it this way and whatever else. Then for each appeal, the appellant presents the appeal, and if they're suggesting that it should be a reduced assessment, they should identify the property that should be receiving the increase in assessment. And quite often they'll say, well, all this water is coming from the road, so the road should pay, which is not the case. I mean, the road is a property owner and gets assessed its fair share, but quite often the road becomes the dumping ground, right or wrong. And the engineer might provide further details on the specific assessments. Again, the suggested hearing process, next slide. If the property owner identified by the appellant is not in attendance, so if somebody says, my assessment should be reduced and Mayor Anderson's assessment should be increased, and Mayor Anderson decided not to attend the meeting because he was satisfied, then you have to adjourn the Court of Revision, don't make any decisions, reconvene, allow the property owner to Mayor Anderson to make his rebuttal or his defense, and then the Court of Revision would make its decision. So you want to hear both sides of any evidence. It basically you hear one side, don't make a decision on that. You need to be able to hear the rebuttal. Now, if Mayor Anderson decided that the second appeal hearing, second sitting of the Court of Revision, he still decided not to attend, well, then you make it in his absence because you've given him that opportunity. So that's adjournment. Then I've got a few sample decisions. And Robin, I don't know, did I email you the Court of Revision info sheet? There's a document. I apologize. I should have done that. Some of these decisions or sample decisions are in there. I'll send that to you that you can share with council or whoever becomes members of the Court of Revision.
That one, that one?
Yes, that one. That's the one. It's just a tool to help you if you're sitting as Court of Revision. Some of these things come out of here, including the sample decisions. First of all, again, remembering that you are no longer sitting as council, you're sitting as a Court of Revision and as an appeal body. Do you have the authority to deliberate in a private room? And the answer is yes. You are an appeal body. It would be really difficult and awkward to try to make a decision on appeal as a panel when the appellant is right there before you. So Court of Revision can go into a back room and make their decision and then come out and make their, issue their decision. And again, this first decision, appeal summary, the appeal should be lowered because the portion of the property drains into another municipal drain. Fair enough. The decision, it's reducing the assessment in that particular one. Next slide. And this is one that you may encounter. The crop damage allowance is insufficient and should be increased. Decision, it's dismissed because it's outside of the jurisdiction of the Court of Revision. Appeals on allowances are heard by the provincial tribunal. Number 3, assessment should be lowered because the engineer has calculated the assessment based on 100% agricultural land use. Actual use is 50% agriculture and 50% bush. And the Court of Revision might decide if that's actually the case, if the engineer said, yeah, I messed up here, then you might reduce the assessment and add it to somebody else. And that owner was present at the hearing, so you don't have to reconvene. Next slide, please. Next one, assessment should be lowered because the owner has no intention of using land for agricultural purposes or whatever purpose it might be. Appeal should be dismissed because the property still has the potential to be used for agriculture. So it's a benefit to the land as opposed to the landowner. The assessment on all private properties, I've seen this one before. Assessment on all private property should be reduced, and an environmental agency like the Conservation Authority or Fisheries and Oceans should be charged $5,000 because of the cost of the studies. And the answer to that is, number 1, you don't have any authority to levy costs on the environmental agencies. And number 2, that's the cost of doing business. You have to comply with law. There's no way around that. So that appeal should be dismissed. And then I think last slide, Court of Revision decisions can be appealed to the tribunal within 21 days. So if you issue a decision as a Court of Revision and people aren't happy, they can appeal further to the tribunal. I think that's it.
Okay, well, that's quite a bit. So I appreciate that. If there are any more questions, I have 2, and I'm going to just go backtrack a wee bit to the petitioning aspect. So engineering costs, it takes a year and a half to, go and do a field study, preliminary meetings, reports to council, etc. Those costs are incurred. Those costs then are assumed as part of the construction cost and the total project cost, which are then assessed to everyone in the assessment schedule. So for example, I'm just using it right now. We sometimes as a municipal authority initiate a petition. We're not paying those costs until the assessment schedule is complete. Am I correct in that?
That's correct. Further, I am not a finance person, but the way I've described it to treasurers is, in my simplified way of looking at it, when a municipal drain project starts up, in my mind, it's like the municipality opens up a line of credit at the local bank. And as you are paying the engineering costs and whatever, the permit fees or whatever, you draw out of your line of credit, and the interest that accrues also becomes part of the cost of the project. So yes, the engineering and the construction, the carrying costs, the interest costs, permits and approvals. If you had to hire a lawyer to defend yourself before the court of the referee, for example, that also becomes part of the cost of the project.
Okay. And then the second question is just with regards to the quarter revision and I think I know the answer, but to when you appoint. So the first and second reading of the bylaw comes to council. At that time, you would appoint the quarter revision as well. In the case that you're going to have an appeal. Because if you don't get any appeals, then you're finished, correct?
So yes, I agree. I would be prepared to appoint a quarter revision at the time you give first and second reading, because that's the next step in the process. If there are 0 appeals, the quarter revision usually still opens. Are there any appeals? No. Are there any late appeals? No. Closed.
So go through the process.
Go through the process. I went to one a month and a half ago that lasted all of 2 minutes. And it was basically what I just went through. So yes, it still is held. And the decision would be there were no appeals filed, the quarter revision closed.
Council, any other questions to Sid? Councilor Meadows?
Yeah, I just have one. With regards to, like most of the municipal drains refer to agricultural Omafra type situations. There are some that are within our industrial lands. So would the industrial lands be more than what an agricultural land is, because you have ground absorption within an agricultural, whereas in a commercial you would have like asphalt, which would, there's no ground absorption. You would have more, I guess, water coming off of that going into the municipal drain. Is that correct?
That is absolutely correct. We just recently developed a new assessment schedule for Bradford, West Gwillimbury, and King for the Holland Marsh inside the polder, because they have an increasing number of greenhouses and hoop houses being built, and they were charged all an equal per acre rate. And they felt that that wasn't fair anymore because of the greenhouses, because of the commercial operations and their paved yards, and that sort of thing. So yeah, that's exactly the sort of thing that should be taken into consideration. So believe it or not, I know they show up in numbers in a table, but if you saw some of the spreadsheets that we develop in order to get to those numbers, there's a lot of thought and consideration that gets there. So yes, and okay. Land use would definitely be a key factor in developing the outlet liability assessments.
Thank you.
Okay, any further questions? All right, seeing none, I do appreciate you coming in and explaining this process to us, and I understand you will be retiring at the end of the year, so if I don't see you or council sees you before then, we wish you all the best in your retirement, and don't be a stranger to Adjala-Tos.
There you go. Thank you, and I certainly will. I won't be a stranger. I may still see you at Roma or AMO. If you do, come up and say hello. I usually participate in the question box panel there.
For sure.
Drainage matters. So.
Okay, sounds great. Good. Thank you very much.
Thank you.
All right, council, there is a resolution to accept the presentation, so that the presentation from Sid Vanderveen, Municipal Drain Leads, RJ Burnside and Associates Limited regarding Review of Drainage Act and Quarter Revision training be received. We have a mover for that. Councillor Cox, seconder, please. Councillor O'Leary. All those in favor? And that is carried. So as indicated when I started the meeting, just for reference again, in a moment here, I will recess the meeting, and then we will resume at the Colgan Wastewater Treatment Plant around 1 p.m. And then we will proceed to go into a closed session for the tour of the plant. We will not be coming back to council chambers to adjourn. We will be adjourning the meeting at that time in Colgan. So for anyone looking to, viewing this online, we will not be coming back on camera to adjourn the meeting once we recess in a few moments. Just to confirm with council and the clerks, any questions with regards to those procedures? Okay, thank you. So I will recess this meeting at 12:17 p.m. at the Colgan Wastewater Treatment Plant at 59 Sparrow Way.